Hi, welcome back. In this subunit, we're going to discuss the UCC approach to the mirror image rule. The UCC's response to the common law mirror image rule is in UCC 2-207. Let's refresh our memories. Remember the issue that implicates the common law mirror image rule. We have an acceptance, and the terms of the acceptance are additional to or different from the terms of the offer. Under the common law mirror image rule, that acceptance is not an acceptance, and we do not have a contract. But what if the parties perform? Well, if they perform, then indeed there was a contract, even though there was no offer and acceptance. Well, the question becomes, what are the terms of the contract, the terms of the offer, or the terms of the acceptance? And the last shot rule says the terms of the acceptance control the contract. The UCC in 2-207 does away with both the mirror image rule and the last shot rule. Now, we're going to go in depth through UCC 2-207. It is a difficult statute to read. It is a lot of fun, but if you're in a grumpy mood, or you haven't eaten yet, or you need some coffee, or anything else, maybe you should put this lesson off for a while. Otherwise, let's jump into it. I think it's good fun. Before we look at the UCC approach, let's refresh our memories about the common law mirror image rule and the common law last shot rule. If you remember, our hypothetical was that a contractor made an offer to a subcontractor. The subcontractor's response was this. And we said that under the mirror image rule, subcontractor's response was not an acceptance. Why? Because it had different terms than the offer. It had different terms than the contractor's offer. So the different terms were 8 months, when the contractor's offer was 6 months. We also said that even if it didn't have those different terms, it would still not be an acceptance. Why? Well, because it had additional terms. It had 2 additional terms. It had a choice of jurisdiction clause, Ohio courts, and it had a choice of law clause, Ohio law. Both of these clauses are not in contractor's offer, and so they are additional to the terms of the offer. Under the mirror image rule, subcontractor's email response is not an acceptance. All right, let's take a quick look at what we're expecting from UCC 2-207. Sometimes it's called the battle of the forms, right? You have an offer form and you have an acceptance form. 2-207 sub 1 has a specific task. It does away with the common law mirror image rule. 2-207 sub 2 has a specific task. It does away with the last shot rule. So here's a little tip. If you are looking at a fact pattern and you are applying 2-207 sub 1, if your answer looks like the mirror image rule, then your answer is probably wrong. Same with 2-207 sub 2. If you're applying 2-207 sub 2 and your answer looks like the last shot rule, your answer is probably wrong. All right, back to our fact pattern. We have the offer from contractor, and we have the response from subcontractor. Now, for us to do an analysis of UCC 2-207, we need a sale of goods. So let's change our fact pattern. All right, so now we have a buyer sending an email to seller, right? And the buyer sends the email on October 1st, and the buyer's ordering 10,000 Model X widgets, pay price of $100,000, delivery by January 15th. And now we have seller's email response. October 1st, so the seller responds on the same day. Seller says, we accept. We will deliver 10,000 Model X widgets to you by January 15th. All right. But you see, we have an additional term. Any disputes under this contract shall be resolved in Ohio courts. If you look at buyer's offer on the left, you see nothing about choice of jurisdiction, right? It doesn't say Kentucky courts. It doesn't say any other courts. So seller's email adds Ohio courts as a term. It was not in buyer's email. Seller's email also adds, the laws of the state of Ohio shall govern this contract. Now the question is this an additional term or is this a different term? And it's important for 2-207 that you're able to distinguish between additional terms and different terms. So this choice of law clause, the laws of the state of Ohio, is this an additional term or a different term? Well, if you look at buyer's email to seller, buyer's offer's term is Kentucky law governs. So seller's email response has a different term. The laws of the state of Ohio are different from seller's terms. Kentucky law shall govern the transaction. All right. Now let's look at 2-207. All right, so we have 2-207 sub 1, which we said does away with the mirror image rule. 2-207 sub 2, we said does away with the last shot rule. And subsection 3, we'll get to it, but that also does away with the last shot rule. Let's focus on 2-207 sub 1. Let's make it a little bit simpler. A definite and seasonable expression of acceptance operates as an acceptance even though it states terms additional to or different from those offered or agreed upon. So what's our first element? Well, this is how you should go through a statute. Go through it element by element. The first element is a definite expression of acceptance. So what we're asking ourselves is, in our fact pattern, was seller's response a definite expression of acceptance? Well, let's look at it. All right, so look at seller's response on the right. Is it a definite expression of acceptance? Well, let's look at it in detail. They say we accept. You don't get much more definite than that. Now, the fact patterns you normally will see will not be that clear. So is there any other language in seller's email response that indicates that it is a definite expression of acceptance? Yeah, right there. We will deliver. Will is language of promise. That is a definite expression of acceptance. One other thing you might consider when doing your analysis about whether there is a definite expression of acceptance, look to see that seller's response, that the acceptance has the same Dickard terms as the offer. So seller's response says we will deliver 10,000 widgets. And if you look at buyer's order, they're ordering 10,000 widgets. So that matches up. Model X widgets, that matches up. And January 15th, that also matches up. So seller's response looks like a definite expression of acceptance. Let's go back to the rule. All right, so our first element, a definite expression of acceptance. We said in our case, yes, it looks like we have a definite expression of acceptance. The next element is it a seasonable expression of acceptance? Seasonable just means, was it sent within a reasonable time? Was it timely? Well, let's go back to the facts. Seller's response was on October 1st. Buyer's order was on October 1st. It looks like the response is a seasonable expression of acceptance. It looks like the response was timely. It's hard to think that a response on the same day would not be seasonable. Let's look for our next element. Our next element is terms additional to those offered. Did seller's response have additional terms? Well, let's go back to our fact pattern. Do you see any additional terms? We already discussed this. There, look. Disputes under this contract shall be resolved in Ohio courts. That's a choice of jurisdiction clause. If we look on the left at buyer's offer mentions nothing about jurisdiction. And so seller's response has additional terms. Does seller's response have different terms? Well, let's look at our fact pattern. Seller's response has Ohio law as the choice of law. That differs from, that contradicts buyer's offer, which has Kentucky law as the choice of law. So seller's email response, seller's acceptance has different terms. All right, so now we know we have an acceptance, a definite and seasonable expression with different and additional terms. Under the common law mirror image rule, seller's response would not be an acceptance. But under 2-207 sub 1, it operates as an acceptance. And so at this point between the parties, there is a contract. Seller's response on the right operates as an acceptance under 2-207 sub 1, even though it has terms that are additional to and different from the offer. All right, back to the rule. So we have resolved 2-207 sub 1. We have said that under our fact pattern, we have contract because we have an offer and we have an acceptance. Now what do we do next? Well, naturally we move on to sub 2. Subsection 2 answers the question, what terms govern the transaction? Do the terms of the offer govern the transaction, or do the terms of the acceptance govern the transaction? Let's go through it element by element. The additional terms are to be construed as proposals for addition to the contract. Well, what does that mean? That means that they are proposals for modification of the contract. In other words, buyer's offer controls the terms of the contract. Seller's response is just saying, hey, will you change the terms of the contract? Unless the offerer expressly says, yes, I agree to your different and additional terms, they will not become part of the contract. Looking at seller's acceptance, we see that has an additional term. Any disputes under this contract shall be resolved in Ohio courts. Under 2-207 sub 2, the first sentence, which we just looked at, that additional term will not become part of the contract between the parties. One of the most important rules of statutory reading is to continue reading. So we read that the additional terms are to be construed as proposals for addition to the contract, which we interpreted to mean that the additional terms will not become part of the contract unless the offeror, the buyer in this case, expressly agrees to them. But the rule continues, so let us continue reading. Between merchants, such terms become part of the contract unless. So we have a special and different rule for contracts between merchants. What is a merchant? Well, UCC has a rule, and you can shorten this rule just by saying a merchant means someone who deals in goods of the kind or otherwise holds himself out as having such knowledge. All right? So that's what a merchant is. We have to ask ourselves, are both the buyer and seller, in this case, merchants? Right? Because the rule says between merchants, which means if both the buyer and seller are merchants, then we have a different rule we're going to apply to that transaction regarding whether the additional terms in the acceptance become part of the contract. All right, it says such terms will become part of the contract in a transaction between merchants unless the offer expressly limits the acceptance to the terms of the offer. Let's assume in our case that both buyer and seller are merchants. So the question is, did buyer's offer limit seller's acceptance of the offer to the terms of the offer? It did. It says the terms of this order control any transaction between the parties. So, buyer's offer expressly limited seller's acceptance to the terms of the offer. In such case, the terms will not become part of the contract. All right, so we could stop there, but let's continue on. The rule says the additional terms between merchants, the additional terms will not become part of the contract if they materially alter it. Well, what does it mean to materially alter? Comment 4 to 2-207 says materially alter means resulting in surprise or hardship if incorporated without the express awareness of the offeror, in this case, the buyer. The question we need to ask ourselves is, if seller's additional term became part of the contract, would it cause surprise or hardship for buyer? I think we can make a good argument that it would not cause surprise or hardship for buyer. Look, when buyer entered into this transaction with seller, buyer knew that either Kentucky would have jurisdiction over this transaction or Ohio would have jurisdiction over this transaction. Now, of course, I'm making some assumptions. I'm assuming that buyer is in Kentucky because buyer chose Kentucky law, and I'm assuming seller is in Ohio because seller chose Ohio courts and Ohio law. So buyer knew that either Kentucky would have jurisdiction over this transaction or Ohio would have jurisdiction over this transaction. So when seller responds with Ohio courts having jurisdiction over this transaction, I don't think it is a surprise for buyer. The question is it a hardship? Is buyer so far away from Ohio that it would cause hardship for buyer to go to Ohio? Kentucky is right next to Ohio. Depends on what part of Kentucky buyer is from. We need more facts, but at least based on our basic assumption, this inclusion of this additional term into the contract would not cause surprise for buyer. Let's continue reading 2-207 sub 2. Between merchants, such terms become part of the contract unless notification of objection to them has already been given or is given within a reasonable time after notice of them is received. In other words, buyer still has time to object to seller's additional terms. All right, so there's the additional term. If for some reason we conclude that it can become part of the contract between merchants, buyer can still object to it. If buyer sends a seasonable notification saying, I object to that additional term, then it will not become part of the contract. Therefore, under our analysis, seller's additional term, choice of jurisdiction, Ohio courts, will not become part of the contract. Why? Because buyer's offer expressly limited seller's acceptance to the terms of the offer. Now, let's look at the different terms. Remember, we have different terms. Seller's email response says the laws of the state of Ohio shall govern this contract. Buyer's email says Kentucky law governs the contract. The question is, what do we do with seller's different terms? Do they govern the transaction, or do buyer's terms govern the transaction? Let's go back to subsection 2. Now, if you read it, you'll see subsection 2 just mentions additional terms, not different terms. The additional terms are to be construed as proposals for addition to the contract between merchants such terms. It's only talking about additional terms. So just from a reading of subsection 2, it does not tell us what we should do with the different terms. If we look at comment 3 to 2-207, comment 3 to 2-207 indicates to us that there is a drafting mistake in subsection 2. Let's read comment 3. Whether or not additional or different terms will become part of the agreement depends on the provisions of subsection 2. But we looked at the express language of subsection 2, and it only mentions additional terms. Now, here's the thing. When a jurisdiction, when a state legislature adopts the UCC, they adopt the rules. They don't adopt the comments. So, when Ohio or Kentucky or any state has adopted the UCC, the comments are not necessarily part of the law. Therefore, courts are free to interpret the rule as they see fit. Most courts have interpreted 2-207 sub 2 as not addressing different terms. So they have made up their own rule. Courts say that the different terms knock each other out. This is called the knockout rule. Let's see how the knockout rule works. So we see our different terms, Kentucky law and Ohio law. These are different terms. The knockout rule is that they knock each other out. So this is what would happen. There we go. Neither of those terms become part of the contract between the parties. So courts have a choice. They could either apply comment 3 and treat different terms just like additional terms under UCC 2-207 sub 2, or they can apply the knockout rule. Let's look at the application of 2-207 sub 2 to different terms, just in case the court in your jurisdiction adopts this approach. If we applied 2-207 sub 2 to the different terms in our transaction, the result would look like this. Seller's different term would not become part of the contract. It would look like this. Seller's different term would not become part of the contract. But buyer's term, Kentucky law, would be part of the contract. You can see how this result is different from the result that we get by applying the knockout rule. Under the knockout rule, neither term would become part of the contract. Seller would not get her term, buyer would not get her term. In contrast, when we apply 2-207 sub 2 to the different terms, buyer's term remains part of the contract. Let's take another look at our rule. 2-207 sub 1 This does away with the mirror image rule. 2-207 sub 2 does away with the last shot rule. And we'll get to 2-207 sub 3 in a little bit. Let's go back to sub 1. There's one sentence, one clause we didn't talk about when we talked about sub 1. Unless acceptance is expressly made conditional on assent to the additional or different terms. So remember, under sub 1, we have a definite and seasonable expression of acceptance even though there are additional or different terms. But I might draft my acceptance so that it is not an acceptance. If I make my acceptance expressly conditional on the offeror's assent to the additional or different terms, then my acceptance is not an acceptance. Let's take a look at how that would come up. So this is our fact pattern. You remember it? I didn't change anything. But now I am going to change something. We'll add a clause to seller's email response. So imagine seller said this in the email. This acceptance is expressly conditioned on your acceptance to our terms or of our terms. Thus, seller's email is no longer an acceptance simply because it has this additional sentence. You see, 2-207 sub 1 says a definite and seasonable expression of acceptance operates as an acceptance unless acceptance is expressly made conditional on assent to the additional or different terms. Here, we see the sentence that we have added to seller's email does that. It says, this acceptance is expressly conditioned on your acceptance of our terms. Now, we look at these two correspondences and we have an offer, but we don't have an acceptance. This means we do not have a contract between the parties. But let's say that the parties aren't reading these correspondences as carefully as they should. And they go on and they perform the contract anyway. Seller ships the goods to buyer, and buyer accepts the shipment of goods. Now what? Well, clearly we have a contract, but we don't have a contract based on the emails. We have a contract based on performance, based on conduct. All right, you'll see that UCC 2-207 sub 3 deals with this exact situation. We have a situation where we have conduct by both parties which recognizes the existence of a contract. Seller shipped the goods, buyer accepted shipment of the goods. There is a contract between the parties. Sub 3 says that this is sufficient to establish a contract even though the writings of the parties do not otherwise establish a contract. Remember our writings between the parties? We had emails going back and forth. We had an email from buyer, an email from seller, and we concluded that there was no contract between the parties. So, what do we do in this situation? What are the terms of the contract between the parties when conduct establishes the contract and not the correspondences? Well, sub 3 says, in such case, the terms of the particular contract consist of those terms on which the writings of the parties agree. So we're still going to look at the writings, but we're going to see where the writings agree. Well, let's go to the exercise. Let's do this exercise. Let's see where the two writings agree. First, do the two writings agree that Kentucky law will govern the terms of this transaction? Well, no, they do not. Buyer's email says Kentucky law governs the terms of this transaction. Seller's email says the laws of the state of Ohio shall govern this transaction. So the writings do not agree on Kentucky law. Therefore, under 2-207 sub 3, Kentucky law is not part of the contract between the parties. It's gone. All right, where do we go next? Any disputes under this contract shall be resolved in Ohio courts. Do both writings agree to this term? Well, buyer's email doesn't, so this is gone too. All right, where do we go next? Here we go. The laws of the state of Ohio shall govern this contract. Do both writings agree to that? No, they do not. So under 2-207 sub 3, this term does not become part of the contract. It's gone. All right, so I know 2-207 was a lot to learn, but it's an important exercise. You need to be able to work your way through complicated statutes. 2-207 might look like a complicated statute, but it's nothing compared to statutes you will see in business organizations law, environmental law, securities regulation. So you have to start building these skills to be able to read a statute, go through it, and apply it to a particular fact pattern.